Ladies and gentlemen, I welcome all to my channel. I am S.M.RAZIAQ and today we are going to discuss about the cancellation of documents. How to cancel the documents. In this video, we are going to see how we can cancel a will, how we can cancel power of attorney, how we cancel settlement deed and also the sale deed. The procedure to be followed to cancel the will, power of attorney, settlement and the sale deed are discussed in this video. So first let us see how to cancel the will. I have already explained about the nature of the will. Will is nothing but a recording, a registration recording the intention of the testator, how his property to be disposed or shared as per the desire of the testator. Here testator means who makes the will is called testator. So supposing a father makes a will and says that the property A should go to son and property B should go to daughter and property C should go to his wife, the maker is called testator, the son, daughter and wife are the beneficiaries. So here in the will, the maker, that is a testator, only records his desire, his intention and direction, how his properties, how the properties belong to him and how the property left by him should be distributed or shared to his legal heirs or to any persons. So supposing a person makes a will and he wanted to cancel the will, he can simply go to the concerned register office where he has executed the will and he can simply cancel the will saying that I am cancelling the will. Here in the will, here the person making a will is only recording his intention and so he need not get any opinion, consent or the concurrence of the beneficiaries. So supposing a father makes a will and after 1 month or after 6 months or after 3 years period, he wanted to cancel the will, he need not get the consent of the son or daughter or wife for the cancellation of the will. Because he himself has made a direction, registering, recording his intention to be taken out at the time of his death. So here the consent of the beneficiary is not necessary. He can directly go to the register office and cancel the will. So cancellation is also simple. He can simply put a cancellation deed. In the cancellation deed, he can simply say, I have made so and so will. Now I have decided to cancel the will. So I am cancelling the will. So that the job is over. Now the second document is called power of attorney. Power of attorney is called, there are two types of power of attorney. One is called general power of attorney and the second one is called specific power of attorney. In the power of attorney, the person making or executing the power of attorney appoints another person as his agent or attorney to do some job on his behalf. So here in the power of attorney, a person appoints another person as an agent. He only gets the right to do some job which is dictated by the principal, that is the maker of the executor of the power of attorney. So here also, supposing a person decided to cancel the power of attorney, he can simply go to the register office and he can simply register the cancellation deed saying that I have executed so and so power of attorney. now I have decided to cancel this power of attorney. So I am cancelling the power of attorney. If you make such and such type of declaration or such a type of document with the name cancellation document, cancellation deed, that it itself is sufficient. Automatically the registrar will register the thing automatically. By through this method, a will and the power of attorney can be cancelled. Both in the will and in the power of attorney, the property is not transferred. No transfer took place under the will or under the power of attorney. As far as the will is concerned, the property will be transferred in the event of the death. So only after the death of the executor, the property will be transferred. Here, the general power of attorney authorizing a person to sell the property, he will get the agent will have the power and authority to sell the property or transfer the property as long as it is not revoked, it is not cancelled by the principal. Principal means who makes the power of attorney is called principal, to whom the power is given, authorization is given, permission is given is called agent or attorney. So now, if supposing A gives a power of attorney to B to sell the property, and the B acted on the basis of the power of attorney and sell the property and executed the sale deed, then it will be binding on the principal. Suppose father gives a power of attorney to his son, and the son goes and sell the property, automatically, suppose the son goes to the registry office and make a sale deed and put a signature on the behalf of the father and sell the property, the action is complete, the property is transferred. So in that case, the father cannot go and cancel the power of attorney because the power given is already executed and the property is transferred. So in such circumstances, even if the cancellation of power of attorney is done, that will not have any effect. So if a person gives a power to sell the property or for any other thing, and the cancellation is done, cancellation document is registered, the moment the cancellation document is registered, the power got extinguished. Then thereafter he cannot transfer, or the agent cannot make any sale deed, cannot make any document. So prior to the cancellation, if the agent execute the sale deed on behalf of the principal and transfer the property or sell the property, then it will be binding on the principal. So this is the conditions. So as far as the power is concerned, if the agent has not acted upon, has not done, has not sold, has not transferred the property, he can cancel the document. Regarding the cancellation procedure is concerned, the principal who gives the power can directly go to the registry office and he can make a cancellation deed in 100 rupees stamp paper and get it registered. That is all. For that cancellation also, the registrar will collect only a nominal fees around 100 rupees to 500 rupees only, the expenses. So that can be done. The registrar may ask the original power of attorney. They may ask to produce the original power of attorney so that he can make an endorsement saying that this power is cancelled in the original power of attorney. Supposing you gave the power of attorney to one person, the original is with the agent. In that case also, the registrar cannot compel the person that I will register the cancellation only after the production of the original power of attorney. He cannot scale like that. If the registrar says anything like that, that is also not correct. So suppose A gives the power of attorney to B and B did not act bona fidely, he acted malafidely and he did some wrong, then the person who gives the power can directly go to the registry office and cancel the power of attorney. For that thing, he need not produce, need not call the agent to come and sign the document. The agent need not be, signature of the agent need not be, is not at all record, and registrar also cannot compel the signature of the agent or production of the original document. If he may ask the document, you can simply say it is with him or it is misplaced or something like that. On the basis of that, you can cancel that deed. Once the power of attorney is cancelled, you have a duty to inform the agent saying that I have cancelled your deed through so and so document. So your power authority given to you is come to an end. It has ceased to be existing. It will not have any effect. So you should not do anything on the basis of the power of attorney given previously. So that once you give the notice to the agent saying that the power is cancelled, then he cannot act. Supposing, even after cancellation, even after the intimation of this cancellation of deed to the agent, if he did any acts, that will not be binding on the power of attorney, general principle. So if anything, suppose you give the power of attorney to another person and he cancels the document, and thereafter he goes to the register office and makes a sale deed, or suppose thereafter he go to the own person or approaches a person and gets some advance on the basis of the showing the original power of attorney and collects some amount, then that will also not binding on you. In that case, it will be binding. Then the person who gave money to the agent can collect the money only from the agent. The agent alone will be responsible. Strictly speaking, he may say the principal liability will be fixed only on the agent, and if he violated such things, then we can also file a criminal case saying that you have gone beyond the limit, you have exceeded the authority, and what you have done is not true, it is fraud, cheating, like that. You can make any case, a criminal case against the power of attorney agent. So this is the procedure regarding will. And now let us see the third one, the cancellation of settlement. As far as the settlement and the sale are concerned, both are transfer of properties. Both in settlement, the property transfer from one person to another person. In sale deed, the property is transferred from seller to buyer for consideration. The seller receives some money from the buyer and transfer the property. In settlement, the settler, that is who gives the property, may give the property out of love and affection, or he may give the property with some conditions, or he may give the property gratuitously without receiving any money or without any reasons. So here the property is also transferred from one person to another person, maybe out of love and affection or for any other reasons. He need not receive any actual sale consideration from the person who receives the property. Here the transfer is totally completed. So as far as the settlement is concerned, the settler should give the property to the settlee, and he should have the title over the property, and the property transfer should have been done without any coercion. It should be done with free consent. And the settlee should accept the settlement and take the property and take the possession of the property, and the delivery of the possession should be complete. Once these three elements, settler, settlee and delivery of possession and acceptance of the property by the settlee is done, the transfer is complete. Once these three possession of the property is delivered and completed and accepted by the settlee, then it comes to an end. The settlement is totally complete in all aspects. So then thereafter it cannot be cancelled by the settler for any reasons. However, supposing the father gives the property to the son, saying that with some conditions, saying that you should maintain me, or I am giving the property A to son, we should conduct the marriage of daughter out of his own expenses. So for that sake only I am giving this property. Like that, if you put some conditions, or suppose the father gives a property and says that you should maintain myself and my wife, mother and sister till our lifetime, then the son can accept such settlement with such conditions. So son cannot simply take the property and push away ignore these conditions. He cannot ignore. If you want to accept the settlement, he should accept it with such conditions. The father say you should maintain me, my mother, and marry or and conduct all you should conduct the marriage of to the daughter, and you should bear all expenses like that. If the father put a condition in the settlement deed, the son should comply all those things. If suppose he receives the property and fail to comply all those things, any of such condition, then the father has the right to cancel the settlement deed. That is, now under Senior Citizenship Act, special act has been passed, wherein the various cases which is reported, just came to the government's knowledge, that after receiving the settlement deed, son fails to maintain their parents. So when any such complaint is that, under Senior Citizenship Act also, the cancellation, the father can cancel the document. Regarding in all other aspect, he cannot simply cancel the document, settlement deed. Now the last one is called sale deed. Once the sale took place for consideration, then the seller cannot go on simply cancel the settlement, sale deed. So sale deed once done, it's final in all aspect. He cannot simply cancel the sale deed. In many cases, I have seen that the builder who develops the property, who develops the property and agrees to construct some flats, they normally used to make a sale deed, under which they used to convey undivided share in the land. Certain percentage of undivided share in the land is conveyed to the purchaser, and thereafter he will make an agreement called construction agreement. Under the construction agreement, the builder agrees to construct some flat and some facilities in the flat. Like what the construction agreement will be there. Sometimes what happens, the builder will not be in a position to hand over the possession of the property. He may not complete the building. There may be delay. Then the dispute may come. Then in that case, the buyer who paid money, he will demand the builder to return the money, for which in which circumstances the builder will insist him to make a cancellation deed, cancelling the sale deed. Strictly speaking, such type of cancellation is not valid. This is my opinion. Because once the sale is complete, it is always complete in all aspects. It cannot be simply cancelled. So, what they have to do now, in that case, if they want to make any such cancellation, then they will have to reconvey the property to the builder or to any other person. That is the right thing. Because sale, once, as far as the sale is concerned, when the person gives some consideration and takes the property and the property sale deed is registered, it is final in all aspects. It cannot be cancelled by just going to the register office and making a cancellation deed by a seller and the buyer. So cancellation, such kind of cancellation cannot be done. However, suppose such type of sale is done by fraud, by mistake, or some other reason which is not beyond the control of the which is not beyond the control of the parties, then in that case they can go for cancellation of the deed. Assuming for a moment, suppose the seller wanted to make sell the property plot B. Instead of plot B, he wrongly types the word that plot A is sold under the document. So in that case, what they can do now, they may go for cancellation of the document, saying that by mistake a mistake has happened, or suppose by force and by supposing a person is there is no free consent. Suppose a person is forced, threatened, or intimidated, And because of that such intimidation, because of such pressure, and he was supposing a person came to the kidnapped his daughter and asked the owner of the property to make a sale deed and get it registered in favor of the party. In that case, such criminal, suppose such a criminal threatening is a transfer made by of threatening, force, coercion. In that case, that can be cancelled. So in that case, if you want to go on to cancel, if you want to cancel the document, if both the parties go to the concerned registrar and say make out a reason, because the transfer of property is nothing but a contract. One person pays the money and takes the property. Suppose such transfer, such contract is not done in accordance with the contract law, and it is violative of contract, the general principle of contract, then in that case it can be cancelled for the grounds mentioned in the Contract Act, Indian Contract Act. So supposing the transfer is made by mistake, by threat, or instead of one property, some other property is mentioned, in that case that property can be cancelled by the parties going to the court. As far as suppose the registrar refuses to make any such cancellation deed, then the parties may, in settlement, suppose a father was threatened that son threatened the father and asked him to make a settlement deed, and because of that force, because of that threatening, the father executed a settlement deed. Otherwise, suppose a buyer threatened the seller and kidnapped his daughter and asked him to make a sale deed, and he, on the basis of that pressure, the person has made a sale deed. In that case, if the son or the buyer did not come to the registrar office to make a cancellation deed, then the aggrieved person may go to the court and file a suit for declaration, declaring that this sale deed, the sale made by so and so is null and void. The settlement made by so and so settlement deed is null and void. It has no validity, and you can also concern register as a party to the suit, and also ask the direction of the. You can also pray for a direction from the court to direct the concerned registrar to make a cancellation deed registered and to cancel the particular document. So, supposing a settlement deed or sale deed is executed without free consent or by coercion or by mistake or by any threatening, in that case, the aggrieved person can go to the court and file a suit for declaration declaring that so and so settlement deed or so and so sale deed is null and void. Then he can also implead the concerned sub-registrar as a party, and in the same suit we can also make a prayer for directing the concerned sub-registrar to cancel the particular document, and to note that to make an entry in the registration records that such and such document is cancelled and such a document is not valid. Thereafter, the concerned registrar, on the basis of the direction, the court's judgment and decree can be registered in the concerned registrar office to the effect that such and such documents, sale deed or the settlement deed is cancelled as per the order of the court. Then automatically the property will come back to the original owner. This is the procedure. Regarding the settlement deed and sale deed cancellation, I will make a separate video in detail mentioning the detailed procedure, so that it will be easy for the concerned persons to know the detailed procedure for the cancellation of sale deed and settlement deed. So I will come with another topic. So legal knowledge is power. You can watch our video through which you can gain your knowledge. And if you have any doubt in the law, you can watch my videos, and I have more than 200 videos in my channel, in Tamil and English channels. That will be helpful to you. The playlist will also be helpful to you. In addition to that, if you have any doubt, you may also contact me or to my phone number. If it is possible, I will also help you. The knowledge is power. If the legal knowledge is, it will not only gives you power, it will also give you strength, confidence in your life. So if you feel that this document will be useful to any of your friends or relative, You may also share this video to those people and through which you can also help your friends and relatives. And I will come again with another topic. Until then, goodbye. Raziaq Ali.